Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about privacy in text messages. Cases that should have gone to the Supreme Court of Canada, but didn't. In the course of a sexual assault trial, the Crown sought to introduce text messages that the accused had sent to the complainant. The purpose of introducing those messages was try to establish that this person was guilty of not only sexual assault, but also luring underage people. The accused argued that he had a privacy interest in the text messages and that the Crown was required to prove that they were admissible before they could be used. A charter challenge was brought and he was found to have sent the messages. The police unlawfully intercepted them, but the court determined that the messages should nonetheless be admissible under Section 24 sub 2 of the charter. And this case raises a very important issue because essentially the accused pointed out on appeal that there is a different standard between how text messages are treated as far as a privacy interest when it comes to a complainant in a sexual assault case, where there is an automatic assumption that they have an expectation of privacy and can't even be cross-examined on the contents of those text messages until an application is brought to the court in order to prove why there is a basis for cross-examination. But when it comes to an accused individual, they can be cross-examined on the text messages, and if the text messages are determined to be admissible, whether they were obtained lawfully or obtained in breach of the charter but nevertheless admissible, the Crown can just use them without any particular other application. Moreover, there is other case law that has been developing that says that individuals do not obtain or maintain privacy interests in the type of communication that's at issue because it forms the gravamen of the offense, which is inconsistent with privacy interests that are retained in all sorts of other things that may form the offense itself, like drugs that are hidden in a residence. You have a privacy interest in what's in your residence, including the drugs that might be hidden there. So what is any different about text messages? And why should people who are accused of sexual assault have their privacy interests in their text messages treated differently than people who are complaining of sexual assault and who are the alleged victims of sexual assault? The Supreme Court of Canada could really have sorted out this muddy and seemingly on its face unfair application of the law of privacy as it pertains to the different parties in a criminal trial, and could have tried to square this with the notion that a criminal trial must be in paramountly concerned with fairness to the accused. And this seems to be a situation where that fairness is upset in the other direction. Hopefully the Supreme Court of Canada has an opportunity to hear cases like this in the future and make decisions about the privacy interests that people retain in their text messages as we continue to be in an increasingly digital form of communication these days. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazenbull Creative for putting together these videos. Please like, subscribe, and share with your friends.